Well, apparently it takes an order of the court to declare that the government cannot discriminate on the basis of sex or race. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. 2 streams ago, Robert Barnes and I tackled a lawsuit which was filed against the Biden government on the basis that subsidies that were being offered to farmers was based on a racist policy in that it prioritized marginalized farmers over non-marginalized farmers, which effectively meant that non-white farmers would not be getting this subsidy. The government is giving certain benefits to farmers, among other people, but we're focusing only on the farmers. Those benefits involve loan forgiveness and basically an additional, cash injection, an additional amount given to the farmers, except only based on ethnicity, in that they're targeting racial minority farmers for this benefit and not all farmers. And so one farmer in particular out of Texas filed a class action lawsuit on the basis that this is just outright discrimination, giving grants to farmers but only non-white farmers. I think that's the essence of the lawsuit, right? And that's the essence of the program that is at issue here?
Yes. So the plaintiff happens to also be the Secretary of Agriculture of Texas, but he's only suing in his individual name. And this is one of the first suits brought by the America First legal group.
Well, at the same time, some restaurant owners are also suing the Biden administration on the basis that the COVID relief that the Biden administration was offering itself was also discriminatory in that it prioritized women and marginalized groups to other groups,
that being white people.
In the United States District Court for the Northern District of Texas, Fort Worth Division, Greer's Ranch Cafe et al. Plaintiffs versus Isabella Casillas Guzman in her official capacity as administrator of the Small Business Administration and United States Small Business Administration defendants. Order. Before the court are plaintiff's motion for temporary restraining order filed May 16, 2021 and defendant's response filed May 18, 2021. Plaintiffs seek a temporary restraining order to enjoin the Small Business Administration from distributing $28.6 billion in grants awarded to a priority group based on race or gender. Having considered the motion, briefing, and applicable law, and for the reasons set forth below, the court grants the motion. The fact pattern in this case is pretty straightforward. Restaurateurs who have suffered under the COVID lockdown measures were applying to the government for relief that the government promised, but lo and behold, the government promised relief prioritizing certain races and genders before others, and lo and behold, by the time those other races found the time to apply or got their applications in, all of the money that was offered to support these small businesses would have been gone. Background. Plaintiff Philip Greer owns and operates Plaintiff Greer's Ranch Cafe, a restaurant which lost nearly $100,000 in gross revenue during the COVID-19 pandemic. Collectively plaintiffs. Greer seeks monetary relief under the $28.6 billion Restaurant Revitalization Fund, RRF, created by the American Rescue Plan Act of 2021, ARPA, and administered by the Small Business Administration, SBA. Greer prepared an application on behalf of his restaurant, is eligible for a grant from the RRF, but has not applied because he is barred from consideration altogether during the program's first 21 days from May 3 to May 24, 2021. During that window, ARPA directs SBA to, quote, take such steps as necessary, end quote, to prioritize eligible restaurants, quote, owned and controlled, end quote, by, quote, women, by, quote, veterans, end quote, and by those, quote, socially and economically disadvantaged, end quote. Everyone can apply, but some people get treatment on a priority basis. All animals are created equal, except some animals are created more equal than others. And sure as sugar, what happens. There's a finite amount of money in that pot, and that money goes quickly. Just 9 days into the 21-day window, the SBA announced that, quote, a total of $2.7 billion of relief funds have been distributed to 21,000 restaurants since the fund opened, end quote, and that it has already received, quote, more than 147,000 applications from women, veterans, and socially and economically disadvantaged business owners, end quote, which are, quote, requesting a total of $29 billion in relief funds, end quote. With the prospect that the SBA may distribute the entirety of the $28.6 billion appropriated by Congress before applications from non-prioritized applicants like Greer are even eligible to be processed and considered, plaintiffs sued defendants SBA and Isabella Casillas Guzman in her official capacity as administrator of the SBA. Shortly thereafter, plaintiffs moved for a TRO enjoining the use of race and sex preferences in the distribution of the fund. The motion is now ripe for the court's consideration. The judgment then goes on to explain what a TRO is. That is a temporary restraining order, and it's basically, as the court describes, a highly accelerated injunctive relief. And for those of you who have been around the channel for long enough, you know what an injunction is and what criteria need to be satisfied in order to obtain the issuance of an injunction. injunction, but the court goes over it, so let's just go over those 4 conditions. A preliminary injunction is an, quote, extraordinary remedy, end quote, and will only be granted if the movement carries its burden on all 4 requirements. The court may issue a preliminary injunction if the movement establishes 1. A substantial likelihood of success on the merits, 2. A substantial threat of irreparable harm, 3. The balance of hardships weighs in the movement's favor, and 4. The issuance of the preliminary injunction will not disturb the public interest. Spoiler alert, the plaintiff is going to succeed on all 4 grounds, but not before the defendant seeks to have the motion dismissed on the basis that, yes, the plaintiff lacks standing. Defendants contend that plaintiffs lack standing to bring their claims because, quote, Greer admits that he has not yet applied for RRF funds despite his eligibility to do so, end quote. To satisfy the, quote, irreducible constitutional minimum, end quote, of standing under Article 3, a, quote, plaintiff must have 1. Suffered an injury in fact, 2. That is fairly traceable to the challenged conduct of the defendant, and 3. That is likely to be redressed by a favorable judicial decision, end quote. And the court concludes that the plaintiff has in fact sustained an injury in fact for the following reasons. To show a harm based on an allegedly unconstitutional application process, a plaintiff, quote, must at least show that he is likely to apply in the reasonably foreseeable future, end quote, if the state actor were not unconstitutionally barring him from the fruits of the application process. A plaintiff, quote, can show this only if he is able and ready to apply, end quote. Thus, the court concludes that plaintiffs have sufficiently alleged an injury in fact. The plaintiff then goes on to address the traceability aspect, which is relatively self-explanatory, meaning that the injury in fact is sufficiently traceable to the government's actions, but wait until you read the justification for the government's actions by the government's own admissions. According to defendants, quote, Congress has heard a parade of evidence offering support for the priority period prescribed by ARPA, end quote. Among these, a House report specifically recognized that, quote, underlying racial, wealth, social, and gender disparities are exacerbated by the pandemic, end quote. That, quote, women, especially mothers and women of color, are exiting the workforce at alarming rates, end quote. And that, quote, 8 out of 10 minority-owned businesses are on the brink of closure, end quote. Expert testimony describing how, quote, businesses headed by people of color are less likely to have employees, have fewer employees when they do, and have less revenue compared to white-owned businesses, end quote, because of, quote, structural inequities resulting from less wealth compared to whites who were able to accumulate wealth with the support of public policies, end quote, and that having fewer employees or lower revenue made COVID-related loans to those businesses less lucrative for lenders. Expert testimony explaining that, quote, businesses with existing conventional lending relationships were more likely to access PPP funds quickly and efficiently, end quote, and that minorities are less likely to have such relationships with lenders due to, quote, pre-existing disparities in access to capital, end quote. And there is more. I'm just going to freeze frame on the screen so you can pause and read it at your leisure if you so choose. And what conclusions does the court come to? The court comes to the conclusion that even if these are true, they are not industry specific and can therefore not justify the discrimination as relates to these particular businesses. This evidence largely falters for the same reasoning outlined above. It lacks the industry specific inquiry needed to support a compelling interest for a government imposed racial classification. While the court is mindful of these statistical disparities and expert conclusions based on those disparities, quote, defining these sorts of injuries as identified discrimination would give governments license to create a patchwork of racial preferences based on statistical generalizations about any particular field of endeavor, end quote. Quote, racial classifications are suspect, and that means that simple legislative assurances of good intentions cannot suffice, end quote. Thus, the court concludes that the government has failed to prove that it likely has a compelling interest in, quote, remedying the effects of past and present discrimination, end quote, in the restaurant industry during the COVID-19 pandemic. For the same reason, the court finds that defendants have failed to show, unquote, important governmental objective, end quote, or, quote, exceedingly persuasive justification, end quote, necessary to support a sex-based classification. And then when it comes to the criteria of irreparable harm, the court concludes that yes, the plaintiff will suffer irreparable harm because by the time the plaintiff can submit his application, there's going to be no money left to give that applicant. Accordingly, the court concludes that plaintiffs will suffer irreparable harm absent a TRO because plaintiffs are experiencing race and sex discrimination at the hand of government officials, and the evidence submitted by plaintiffs indicates that the entire $28.6 billion in the Restaurant Revitalization Fund may be depleted before plaintiff's application can be considered for relief under the program. These injuries are also irreparable in light of defendants' sovereign immunity and plaintiff's inability to seek damages. The court then deals with the balance of hardships and the public interest and concludes that these factors weigh in favor of the plaintiffs. The defendants argued that if a TRO is issued, they wouldn't be able to get any money out to anybody, and the court says no, if the TRO is sufficiently narrow, you will be able to satisfy the objectives of this law in a non-discriminatory fashion. For the foregoing reasons, the court concludes concludes that plaintiffs have met their burden of proving each of the 4 elements for a temporary restraining order. Accordingly, the court grants plaintiffs' motion for temporary restraining order, directs plaintiffs to file their application for an RRF grant on or before May 19, 2021 at 5 p.m. and enjoins defendants Isabella Casillas Guzman and the United States Small Business Administration and their officers, agents, servants, employees, attorneys, designees, and subordinates, as well as any person acting in concert or participation with them, to process and consider plaintiff's application for an RRF grant as of May 13, 2021, the date of the complaint was filed. Now we will see if this application so ordered by the court gets fair consideration by the government, but at the very least the court ordered the defendants to consider the application, so I guess there is a victory there to some extent. But if this judgment proves nothing else, it's that if the government is going to discriminate, they had better have a darn good reason to do so, and their discrimination had better be correlated to the objectives sought. To be continued, we'll see where this goes. Robert Barnes and I will be discussing this during our next live stream on Sunday, my birthday. But if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
You don't win friends with salad. You don't win friends with salad. You don't win friends with salad. You don't win friends with salad.
If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch, anti-media, politics ruins everything, keep calm and vlog on. I think someone's parking behind me now. Or maybe they were just staring into my office. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. All of my stuff is also on Rumble, but if you want to support us, you can also find us on Local. That address is
vivabarneslaw.locals.com.
But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah! I missed the screen. Booyah!